Thank you very much, my friend uh, Adam, and also thank you very much, our listeners. Today is a beautiful day. It's a beautiful day because, unlike other days, we are blessed with a man in our Lego fraternity. We call him the grandfather of the employment revolution. And I also want to disclose that Council Patterson Arinaitwe is a person I've personally looked up to in our profession.
Thank you.
And the Patterson is one person who will pick up your call at all material times. And when I received the demand from the listeners to the effect that we want to understand where we stand, because long ago, for the Gen Zism, they have grown up with their fathers, wake up in the morning, put on suits, go to office, make sure they're there by 8, and come back at 5. And they work from Monday to Friday. And if they're in government employment, they know that the moment you reach retirement age, then you expect to get your pension. If you are in private practice or NGO, whatever, the understanding has always been that I will be expected to either get my NSSF savings. I will be confident that maybe I will get health care. My time is defined, that I work for 8 hours, and hence the definition of extra time.
Yeah.
But looking at the history of employment world over, it has gone on changing and changing. Uh, you realize that the revolution in the employment starts way back. Uh, starts way back in the period of the gathering, like Patson has always talked about, where they tell us that our great grandfathers used to be fruit hunters, and they would work in groups and simply collect a few things for survival. And that season, that generation, transformed into another generation where they had this, what we call the agricultural revolution, and then they have this organized farming, then we have the industrial revolution, and then now here we are. Things are not the same. And there would be no better person to host to discuss for us today's topic, which is gigs, bots, briefs, and the employment in the current uh, employment dispensation in the digital era. Uh, Today, you realize that 70%, according to the recent reports, show that 70% of the youth are now into digital kind of employment, digital creation. They are creating videos, they are on TikTok, they are having what we call, in the Gen Z language, gigs. But one question remains unanswered. And the question is, how are these people protected? Not long ago, Safe Border rewrote her contracts. And I think that was 2021. And they said, look, these guys, we use the Safe Border people, are not employees. They are contract workers. And now the question is, you have this young man who has left university. He has been contracted by an app called Safe Border. This app monitors his rating. This app monitors his time. This app can deny him access. That means it can actually terminate his employment. And the young man is looking at Agre, who is in another sector, and Agre is flashing his employment contract. The employment contract is giving Agre NSSF. The employment contract is giving Agre a security of tenure, is giving Agre, clear terms of engagement. Agre knows who is going to fire him. And Agre knows who to sue in case he's fired. So there would be no better person to invite. Therefore, ladies and gentlemen, let me take the singular pleasure of introducing our celebrated revolutionist in the employment sector. I would want to use the word revolutionist in the employment sector because when many of us were running to practice land, practice criminal, practice all these areas, Patson just pulled from the veil of the blue and said, you know what, employment. And you know what, we are now having employment workshop, employment training. I wish I had better description of Arena Itwe. I prefer to describe him as the Duke of Chagaju. My brother Arena Itwe Patson, I want to request that the unspated audience get to know who is Arena Itwe Patson. Thank you.
Yeah, thank you, Tony, for hosting me and for the generous introduction and the generous word said about me. It's usually refreshing for a very professional and an astute one to have kind words about the other. Those are things that are long gone. But I do appreciate, but also what you're building in these spaces in terms of, sharing knowledge and ensuring that we cross-sell each other in our areas of specialization and expertise, but also enabling the community and the ecosystem we serve as lawyers. I'm a partner at Signum Advocates, and I think I've, like you said, a lot of my work has been in a few spaces, around 3. The other day I was at the family court, and I couldn't find my way around the courthouse because I've not practiced at all. So when I appeared before the judge, the judge asked me what I'm doing at the family division, because that I'm known for Ntinda and Nakasero, that is industrial court and commercial court. Yeah, that's what I do. If I'm not in commercial disputes, I'm really in the employment space. If I'm not representing, I'm adjudicating disputes as an arbitrator. So I've tried to narrow my areas to a few areas, both as somebody who adjudicates over disputes, but also advises businesses to one of the risks that are ever moving, and that is the human resource business. The most important for the business, but also in the current times, it is the most risky. In commercial terms, when you have a commercial dispute, you can easily put a sum and say, in case you lose this case, this is the sum. But employment for the last 20 years has been a moving pendulum. Today you get it right, but there are changes. Because law follows commerce, and commerce has a lot of the human resource embedded in it. So it's interesting to me, and it's intriguing because you are chasing a moving target all the time. So even today, when you say you've got it right, you have a decision, you have a legislation that challenges you to go back to the drawing board to read. So that's what I've been doing for the bulk of my practice. And I like it because of what it provides. One, the fact that employment affects families, it affects the economy,
Sure.
it affects the well-being of so many people. Today you terminate one person, and because of the black tax in our economy, you can affect 20, 30 people because one person lost their job. So I take it as part of change, or part of the process, offering my service to the community to ensure that the right rules are applied and the right advice is consumed. And you've touched an important conversation really on the changing times of employment. And there's one thing that is no longer part of the debate, and that is how technology has shaped the world of work. That is no longer a debate. I think the critical question is whether the employment law has received the memo that technology has actually taken over work. And you've given a very good history of, from the Industrial Revolution, where the challenges that we had at the time was somebody losing their hand with a machine, to times of job security in the 1970s, the times of the millennials now, where job security is very important, to the current times where having a permanent contract is no longer a big deal for a Gen Z. Yeah. It used to be for the people, the baby boomers of the 1960s, 70s, and 80s. But today, if you ask a Gen Z that I'm giving you a 10-year contract, they will say, I don't want. Previously, it was the employee who was fighting to get long-term contract. But times have changed. Now the employee is asking for a short-term because he wants to be available to others. So lots of changes have happened in the world of work. And probably what is not changing at the same pace is the employment law. So how do you get an old-fashioned law, fit it into the modern times? And for me, that intrigues, my practice. And that's why, for me, offering my time for this space is an honor to be invited than the other way around, because it's a space that we play in, and very helpful.
Surprisingly, Patson has a way of downplaying his achievements. And I decided to throw this ball to him. I thought he would change. He doesn't change. But Patson, we are proud of the bar you've set. And it would be very unchristian of me if I don't share with our listeners the Patson they know, or the Patson they don't know. So ladies and gentlemen, forget about Patson's light description of himself. Patson is a member of the International Court of Arbitration. Is a fellow of Center for International Institute of Arbitrators. He holds a Master's of Laws in Oil and Gas. He holds a Bachelor of Laws. And he has a very rich experience, which comes from one of the traditional firms. I must give credit to S&L, and he's a partner at Signum Advocates. I want to tell you, many of us in the practice appreciate the impact Signum Advocates has had on this industry. So we feel it's an honor to share that part of the background. And thank you. So pick it up from there. You were telling us the history of employment because the Gen Zs, like my friend Rhoda, has no idea what happened in the prehistory. She has no idea that at some level, you know, during a certain revolution, during a certain time, there were workers' unions.
Yeah.
For her, she feels, I don't need a workers' union anymore. So, right there.
Yeah.
Thank you.
Yeah, thank you, Tony, and for reminding me about as well my mentors at S&L, and of course my formative years with Professor Varia, where I got my first job and inducted me into employment space. One thing I didn't mention is that when I left law school, I really wanted to teach and practice law. And my first job, I went to Bade Byamcha. By then, Mr. Byamugisha, senior counsel, was teaching at LDC. Professor Varia was at Makerere. And I looked at those two as a very good step for me for what I wanted to be, a teacher and a practitioner. And it so happened that Professor Varia at the time was teaching employment, and he was massive in terms of employment space, especially in terms of litigation. But the bulk, if not his entire practice, was representing employees. So as a young lawyer, I spent time drafting claims for employees in the labor courts, calculating leave days that they did not take. So that's how I learned how many public holidays we have in a year, because I had to calculate times 2 of their hourly rate. Then if you work on Sundays, so you know that there are 52 Sundays in a year, so you start calculating how much. After 6 months, I put in my resignation and I told professor that I can't do employment. It's boring. So I resigned and left. Fast forward, in 2017, I was organizing an employment conference, and I invited Professor Varia to speak. So when I entered his office, he laughed after explaining to him. He said, you resigned because employment was boring. But right now, you have a deep dive into the same space. So how times change. And also to appreciate those mentors over the years.
Just right there. What is the turning point? When does the person who says to hell with this employment and computing leave days and so on come back now into employment law and is organizing employment conferences and workshops?
Yeah. So fast forward, I joined S&L as a litigator. I found the bulk of litigation I was handling was employment. Later, I traveled for my master's in oil and gas in Scotland. I come back and say, I don't want employment again. I want to do energy work and I want to do projects work, which I did. But at the time, that's when the industrial court had also opened its doors. And at the time, almost it was practically impossible for an employer to win a case. It needed a certain level of research challenging the current status in court to get a result. And for me, that challenge was what was also intriguing. As you might be aware, our entire employment legislation is skewed towards the employee.
Sure.
So when the employer gets it wrong, it's almost impossible to defend the case. And for me, that's another challenge I wanted to take on. So a couple of cases I lost, but there was a lot of jurisprudence to learn. So I tried to trace the history of award of damages in our courts. And I was doing a research for a case I was handling. And I realized that there were quite a number of inconsistencies in our courts, especially on the issue of award of damages for unlawful dismissal. So I decided to look at the history from the East African Court of Justice, not this one, the one before the current ESCJ, where the appeals used to go, and get into the Supreme Court of Uganda and see how were cases being handled in as far as application of the common law principles in unlawful dismissal cases. And I authored a 40-page article, which I called a treatise, expressing my disappointment on how courts have been inconsistent on just one issue. And then the industrial court. I recall one of the people I look up to, Philip Kalgawa, picked it up and said, you must present this. This is groundbreaking. So that was the first time, again, the interest came in. We had law series early morning to discuss the paper. I recall coming up, Professor Varia and Dr. Now and Ivan Ngolu were the discussants of the paper. So the journey began again of how do we correct the mistakes. You have courts that are inconsistent, and I'm not saying that they now got it right. There are still inconsistencies over one or two things, especially in regard to damages. So that sparked my interest again of the space here. We need to look at the jurisprudence. As long as we're a common law country that follow precedent, we need to honor it. And if you want to depart, give me reasons. I may disagree with you, but give me reasons why you are departing. And that piqued my interest again. And because now I started representing clients in the oil and gas sector, in the energy space that I wanted to serve in as well, it was an easy route back as you do the oil and gas, but there's still employment in that space. So that's how I was able to recruit myself. But I realized that there was still knowledge gap in so many aspects of our employment law. Remember, it was passed in 2006, September, when we were dealing with the Agua Girls project.
Yeah.
I think the government of Uganda wanted to have funding for the Agua Girls project. They went to the US, Washington, to discuss the funding, and the government told them, you must have legislation that is compliant with International Labour Organization. And that's how the 4 pieces of legislation were passed in one afternoon in 2006. So it had its own challenges that prompted a lot of litigation, inconsistencies, different perspectives on some of the provisions. Hence the need to say, how can a business person who has 400 employees be helped, notwithstanding the inconsistencies and the challenges in the Employment Act? Do the HR people who manage human capital know what needs to be done? Or they will wait for the industrial court to slam them with 800 million in damages aggravated for failure to follow the process. So the discussions of the employment conference, the webinars, was to have the court, the businesses, and the people who manage the human capital come to a conversation and not wait to penalize businesses. Because you can imagine if you have an NGO that is employing 200 people, donor funded, because they've made a mistake, and you slam general damages of 400 million. They don't have a budget for it.
I hear you.
And probably it's not because they wanted to offend the employee, but the law is also not clear. The processes are not clear. So the idea of bringing people together and have a conversation and let court get to understand the perspective, and let the users get to understand the perspective of court, and help the businesses create certainty in as far as the human capital is concerned, is also one of the journeys that have been helpful in trying to create awareness in the employment space and continuing to serve the nation.
Wow.
Yeah.
You bring a very touching story. You sit down and you do research, unsponsored research for this matter, and you are concerned and you're saying, look, there are all these discrepancies. The High Court is saying B, the High Court is saying C, the High Court is saying D. But then the highest court of the land is also having, these contradictions. So you sit down, you're coming down with a 40-page document, and you're saying, no, there are all these inconsistencies. And I think for me, my take home is, in this generation, in this fraternity, it is important that where we are able to contribute to setting a precedent, it comes to help generations. Yeah. Maybe we would not be having this conversation here today. You talk of the AGOA legislation, which was, passed in 4 days, hurriedly. Why? Because it was a conditional kind of grant somewhere, and they're saying. So for me, these conversations are very important because they don't only inform the policymakers, they inform the legislators. And I have had meetings where they say, oh, you talked about blockchain, and I think as government is something we need to look at. So I appreciate, that school of thought where you come out and say, I'm not doing this for money, but I need to help and put things right. Our listeners, once again, my name is Tony Kire Galandi, your host. And today we are having none other than Arina Patson, the grandfather of employment revolution. We can call Professor Barrier the grandfather of employment, but he won't escape being called the grandfather of employment revolution, as many of our listeners refer to you. And for the purpose of this conversation, we intend to structure our theme, in terms of 3 kind of themes. We are going to be looking at digital control and algorithmic power, and we are going to be looking at social protection and the missing minimum wage. And then we are also going to be looking at the legal reform. So I will structure these questions in clusters, and thereafter we should be able to have the latitude to be able to benefit our clients. Not long ago, I tried to paint a picture, and they said that 2021 Safe Border changes its terms of engagement. And the contract says you are an employee, you're a contractor, an independent contractor. You'll be talking to us to an ordinary mind, what's an independent contractor? Because parts on this conversation is listened to by so many people, lawyers, human resource officers, and non-lawyers. And these discussions are really very key. And right there, you are having creation of a sector of employment which is not traditional per se. And if it is to be defined in its traditional form, ideally, my father would look at a completely different definition of an independent contractor. And that has created a number of challenges, because now you are having an employee who is not completely protected in the perception of an ordinary person. Because, number one, when the NSSF wants to check whether I'm paying NSSF for my employees here, they send a person and he knocks and says, how many employees you have, what's their NSSF number, and all those questions. But we're also having this app which is having its employees, and the relationship between them and the supervising body, in this case NSSF, is very limited. The access to this supervision is ideally very limited. They are telling you these are independent contractors. And that takes me to the first phase of questions, and I would want you to guide us in this discussion for our first theme. What does work look like in Uganda's digital economy? And are we witnessing genuine job creation or merely restructuring traditional labor relationships? Number two, with over 70% of youth turning to content creation and digital marketing due to high unemployment. How do these new forms of work differ from gigs on platforms like SafeBorder? And what does that mean for a young man looking for employment in terms of protection? Over to you. Yeah.
Yeah, thank you, Tony. And I think that's a question that has been around for generations. And surprisingly, even courts have not had answers. I think the first case to litigate that point substantively is the famous ready mixed concrete on classification of employment, whether you're an independent contractor or you are an employee. And that classification is very important in many ways. But more importantly, the fact that when you fall into one category, you might be denied certain benefits that accrue to an employee. And that's why that classification keeps changing. Not the principles have remained the same. But the changing world of work is what gives it a life as a debate. So you have those days of casual laborers, whether you're a casual laborer or an industrial worker entitled to protection at work, safe working environment, to the 1980s, where that distinction is about whether or not you be entitled to social protection like pensions or not, to now where it's about whether you're entitled to other measures like leave, like family-related protection under the Employment Act. So that classification has, the principles underlying the classification have not changed. But we are always faced with a debate because of the changing times. Now, traditionally, you had an employer who is the boss, probably with a mustache, breathing under your neck with close supervision. And there's a structure. You have a massive office for the boss, the MD, or the finance and administration at the time, who tells you must appear at 8, leave at 5, and your work is closely supervised. Then you move to the world of technology, where now your boss could be a dashboard. The control could be that app where that you set yourself to say, I will drive myself Uber or Border between 5 p.m. and 9 p.m. And I'm done. So your boss could be algorithm. It could be that dashboard. But the classification has not changed. And that's why even with UK that almost got it right, the debate came up again, including the Uber driver. Who are we? And are we entitled to social protection like leave? If I get injured as a driver in my Uber car, can I get compensation because I was injured in the course of employment? The taxman would want to know whether they should deduct 6% withholding tax or pay as you earn, or whether you are entitled to all those social protection. So that classification is very important. And it changes with the circumstances. Now, when you get into the gig economy, the gig, the way traditionally used to be, and gig came from those who used to sing in bars and casinos. I have a singing gig. I have my 8 to 5 job. But when I'm not there, I'll go in a bar on a Friday and do karaoke. I get some money and move on. It turns into somebody who has a law firm, is employed in a law firm, but during lunchtime he has a gig to do something else. Or he's a lawyer, but he's doing creative art for someone else. Now, because of the nature of the changing work, there's a need to harmonize. Now, you have the insurance sector that tells its agents that, look, you're not an employee, but you go and sell. At what point do you say is an agent under classification of independent contractor to somebody who is an integral part of your business, that in case of an accident, they're entitled to compensation under the Workers' Compensation Act? Or the taxman would want to ask pay as you earn. NSSF would want to ask for the 15%. Because that classification means that if I'm an independent contractor, I do my accounting, I do my business.
Exactly.
You don't own me as an employer, we are separate. Now, every job grade or tribe has to be understood within the context. Who controls the other's work? Is that person an integral part of the so-called controller? Am I using tools to generate my own income, or you provide? So the test of employment as enumerated in the ready-mixed concrete, I think it's a 1960s case, those tests have not changed. Only that the applicability keeps changing depending on times. Now, like supervision. Supervision was close supervision. When the boss's coat is still in the house, you don't go away. But now you have technology that is measuring your productivity based on data. And you don't even have a human boss. So is there a control test under the traditional sense? Of course, yes. Only that what control means has changed depending on the job tribe and the classification. I think the danger you have with the modern job tribes of work, chances are that they might deprive young people of the social protection. And maybe they are more of entrepreneurs than employees. And we also have to let the economy evolve to say if I'm able to do social media, 10 social media accounts for different people, I'm managing their social media accounts.
Yeah.
Maybe I don't need a boss.
Yeah.
I'm an independent contractor.
Mm-hmm.
But if you say you cannot take on someone else, you must manage my accounts alone, then you're controlling me. Then you must give me data. You must give me the smartphone.
Yeah.
Then during the weekend, can you give me time off? Because the law says I must get 48 hours only as normal. If I exceed, give me overtime.
True.
Yeah, so that's why the classification is very important, and the principles have to be adjusted depending on the circumstances of each case.
Wow. Wow. Takes us to the digital control, like you're saying, from human management to algorithmic power. First of all, in your opinion, do you think the law needs to recognize digital control as a basis of employment status? Based on your experience, what should be the test, in your opinion?
I think control as a yardstick to determine whether or not one is an employee still makes sense today as it did 50 years ago.
Okay.
And it's not the only test. It has to be applied alongside others.
Yeah.
Because control, why it's a great indicator of employment, it's never the only test. You have to look at other tests. But you must look at the changes in the times. And I think that point has been discussed ably in the Uber case in UK.
Yeah.
Although the way it's been applied here has also changed. UK has 3 classifications. You have an employee, you have a worker, and an independent contractor. Now, a worker has certain statutory protections, not close to the employee, but also not an independent contractor. So they have a middle classification that we do not have here. And I think even when I've seen some cases in Uganda trying to apply the Uber case wrongly, because again, the test is for a different categorization, the worker, that we don't have here. Because actually here, a worker is the employee in that context. So if one is a judicial officer trying to determine whether a freelancer based in Nairobi supporting business in Uganda, whether the employee or independent contractor, the control has to happen.
Yeah.
If you say, please, I must see you online on the work platform for 5 hours, you're controlling my time.
Exactly.
We may not be in the same space, but you are telling me that I must be in a platform. If you have, let's say, core banking system, you must be logged in, but I'm in US. You're controlling me. If you choose to say, must have a Teams meeting at 9 p.m. So the control is no longer in the physical realm as we used to know it. You must probably later, when the clock-ins came, we need to see your thumbprint in a clock-in.
Yeah.
When we moved away from signing in the book,
which we actually still keep in some areas.
Yeah, to clock in to now signing in the system.
Yeah.
People now have, for instance, embraced Microsoft 365.
Yeah.
That will demonstrate you're on Teams, you're on My Outlook, you're on OneDrive. So you're being controlled within a particular ecosystem called 365. So it's no longer the Big Ben breathing under your neck, but monitoring your digital footprint in the employer's technology footprint as well. I've not seen your digital footprint here. Where are you?
Yeah. Yeah.
That's control, which is distinct from the civil service mentality of, because I'm being controlled, I'll get my jacket, put it on my desk, and go for lunch until tomorrow, trying to circumvent, control and micromanagement.
Yeah. Yeah.
So those classifications keep changing, and they have always be applied within the changing times.
True.
And the judges have to be innovative. Remember, the more you twist economy through human capital, the more you will frustrate innovation, you frustrate economic growth. And sometimes judges, before they say one is an employee or independent contractor, they need to let the private system develop, see, and then see whether there's a need for social protection or to apply the control or allow them to be freelancers or independent contractors who are okay, who no longer need the same kind of social protection as in the 90s. In the 90s, you wanted a job permanent. Giving somebody a contract was seen as lack of social protection. But now, an employee comes and says, I'm going to give you 2 years of my time. Beyond that, I'm out of here. So the power has shifted because of the dynamics of the gig economy, of the platform workers who believe that I can actually do work for 5 people and I don't need to be controlled. And we're moving away from the traditional employment classification.
Yeah, just right there. And for me, my take home, as long as you are controlling somebody, you control his time, you control, that person ceases to be an independent contractor. It now definitely becomes an employee. And that conversation has always been like the chicken and the egg. Yeah? Because the person giving you the money or giving you the gig is saying, but I pay you. You are my employee. But also the person doing the gig is saying, wait a minute, I am an independent contractor. So I want to thank you for clearing that glitch. Why this conversation is very, very important, Patson, is a number of human resource officers are not necessarily lawyers. But also, these human resource officers, a number of them, whereas they have the human resource management, like you have ably said, our Employment Act is diverse, and depending on the lens one is looking at it, we have had so many cases of unfair dismissal, firing the person actually you're not supposed to, you're not even employing, and this creates so many litigation issues. Then before you realize, the question is coming up, by the way, was this one your employee anyway? And the person sometimes raising that argument, no, I was never your employee, then why did you fire me? You are an independent contractor, but then why do you control my time? So I think this clarity, for me, I want to appreciate, that, to thank you. But that also takes me to another thing.
But Tony, I just wanted to add a perspective to that.
Yeah.
That independent contractor employment was almost clarified until there has been a practice now of outsourcing of labor. So you have a firm or a company that provides labor to other employers. Now, in most cases, this outsourcing company does not have the financial muscle. So the understanding is that they get their profit margins based on what they make. So
Yeah.
I will set up a company, look for employees of around 200 and distribute them, especially in the manufacturing. This company needs 50 staff, I can provide them. This needs 30. Now, the challenge happens when such a person who is being paid by this outsourcing company gets into that space. He's being disciplined by the client.
Yeah.
Because they want uniformity, they don't want people to look different. This person is given a uniform. When they're having lunch, they don't want to discriminate. Said, even this contractor, let's give them lunch until such a point when they say, I think we no longer need your services.
Mm-hmm.
And the point now becomes, by the way, who is my employer? Is this company that has my employment contract?
Mm-hmm.
Or this person here?
Who gave me the uniform?
Who gave me the uniform, who feeds me, who gives me leave, and who does my performance management. But the contract I have is for XYZ Outsourcing Company Limited.
Mm-hmm.
That in case I am questioning my termination, they may not even have the financial muscle to pay because prior they get 2,000 per employee they outsource. So the margins are small. But you know that you've been outsourced in a particular, and I've seen this is a growing practice now in the oil and gas sector.
Yeah.
It's been prevalent in the manufacturing, the banking sector have taken on because most of these companies have group payroll limits. So they will say, we can only hire 100 people in Uganda, but your needs are 400.
Exactly.
So it means the 300, you have to look for the outsourcing company who will cater for the payroll.
Exactly.
But technically, they will be with the organization for 2, 4, 5 years as contractors. And that's now a different dynamic to the discussion of independent contractor versus employee. And we've seen in other jurisdictions now the growing trend of what we call joint employment. If your outsourcing agreements are not watertight to avoid control test, and the supervision and the discipline very well, you will end up one person being employed by 2 entities in respect of the same job. And those are risks now because of the current times.
Yeah.
To look at different ways of doing things, but if not well crafted, how you manage them to ensure that there's no transfer of employment from one employer to the other, who will control the day-to-day, who supervises them, between the client and the outsourcing company. The lines can be blurred, and then all of a sudden you have a risky situation on who to blame.
Wow.
Yeah.
And I think that takes us to right there exactly, where you have situations for entities like Amazon, where they use algorithms, one, to do the hiring, but also two, to initiate disciplinary action. And go further after initiating disciplinary action, they actually do determination. So the question is, what happens and who bears this legal responsibility? Who bears this liability for an employee who has been wrongly terminated? Because the bot did the interview. Whatever was done was really the bot did the interview. After doing the interview, it even did the recruitment, the employment. There is no human face throughout that whole process, and including the termination has been initiated automatically. Yeah. You and me know that in our traditional employment practice, if I asked one of my employees here that tomorrow you are not coming to work because of ABCD, then the Employment Act must come into play.
Yes.
Issues of fair hearing must come into play. And where some of those basics have not been adhered to, then the issue of unfair dismissal comes in.
Yeah.
In your practice, in your professional advising of entities of this nature, who should hold liability? Who holds liability under such circumstances?
You know, Tony, that's a progressive. It's a progressive question that the answers may not be clear. Why? Our Employment Act, much as it is a 2006 Act, is a bit old.
Yeah.
Designed based on 1996 UK Employment Act. So what that means that for the last 30 years, the changes at the workplace are not factored in our laws. For instance, when we are faced with COVID situation, we are very reactive because our laws did not envisage such.
Yeah.
Now we have accelerated digital penetration, especially use of artificial intelligence, in a number of ways.
Yeah.
That you know, the judiciary, the legislators, and the employers must be alive to. Because now we can no longer talk about whether or not we need technology in each and every sphere of life, including the work processes, which includes disciplinary process. It's a given now. In organizations are already applying them. The understanding is that then how do you keep the fundamentals? The fundamentals being, for instance, to understand that under our Section 65 of the Employment Act, no one should be condemned unheard.
Exactly.
So if you give me a robot, have I been heard? If I'm presenting a robot, have I been heard? Or should our interpretation of a fair hearing mean there has to be a face? There's nowhere in our legislation that fair hearing means you must have a face. Because the underlying idea in employment space is that one should be given an opportunity to be heard. But who is hearing? Who is interpreting? Yeah. And that requires an ethical use of AI in the process. I think you can use AI as a tool to generate data. If you say that somebody has not worked for 8 hours, I'll use, you know, information data on the system to know that out of 8, you only worked for 2 hours. If it's about performance, I can use data to know that you're a poor performer.
Yeah.
But that's a tool. But you'd want to ensure that basics, like of a fair hearing, keep AI as a tool, not the alpha and omega, because ultimately the decision should be taken by the organization, those that can own the decision. Because I think the right to fair hearing, if you use entirely, AI, the question is whether the employer has actually been heard, and if he has been heard by who. And when you put a lot of robotics in between an algorithm and the checks and the data, the question is, have you satisfied the statutory requirements? So in our integration of artificial intelligence in the work processes, in the discipline, you have to know that certain things require probably human face to it. Especially in employment where empathy now can be the difference between winning and losing a case.
Exactly.
So when you move everything to the platform to determine whether so-and-so is guilty of an infraction, then where is empathy in this? It becomes challenging to do that. So some of the integrations have to go slow with the economy. You cannot fully embrace technology in an era where the law is still 30 years old and the economy has moved on. And our parliament is not moving at the same pace as innovation. So what that means that certain things have to first settle before you fully integrate. But currently, who knew that a disciplinary hearing could be conducted on Zoom? People had to travel from Zombo to come to head office to be heard. But now industrial court says it's okay, we can have a virtual hearing. That's a step to the right direction. And that does not offend the principles of natural justice. In terms of performance management, I don't need to appear fully before the supervisor and fight over marks. You can have a system, as long as the system is participatory, the system allows the employee and the supervisor to have input, and it has the smart guidelines in terms of where the objectives set very well. Are they smart? Are they measurable?
Yeah.
Are they predictable? Are they achievable? Now that information can be used to demonstrate whether or not one is a poor performer or not. Courts have already embraced that. So that's a step. So the understanding is that you can't fully embrace AI, especially in the spaces where human touch is still important. So you have to take baby steps to ensure that the critical safeguards, like somebody should not be condemned and hard, are not compromised.
Wow. I think you bring in a very, very touchy perspective. Baby steps. Our employment law is 30 years old, but we are in the 21st generation, running at the speed of a robot. And there is need for patience in all areas that we should appreciate that the digital space is moving at a marathon space, but then the laws and so on, the speed may not be. So I think from the practice perspective, these are key things which lawyers would want to hear, because so when a client is coming in from where he sits. So conversations like these ones give a very broader perspective. And I think now that also is going to take me to the social protection bit and the regulatory reform. One of the conversations we have had not long ago, at the beginning of this conversation, was these independent contract workers. The issue was these fellows, in one way or another, because of the structure of the environment, they don't have access to NSSF. They don't have access to some of these basic things like leave days. Would want you to look at it from your practical experience. What are your thoughts? How can such employees, either by way of proposing legislation reforms or in the current environment where these so-called independent contractors form a very, very huge part of our employment sector. And then the cloud called independent contractor is now being used by whoever is using these employees, because there's a thin line between an employee and an independent contractor. Even when you say, I don't control your time, you choose when to work. Okay? But then you have also realized that there are bots that will not give you trips. If you talk to these safe border people, these will, they will tell you that if you do not work in particular peak hours when they need you most, then they will not send you trips. So whereas there is no black and white that you are being controlled, but inactively, there is that inactive part where you are actually in the back end being controlled. So I'm forced to work between 4, 5, 6, 7 peak hours, because I know if I don't do that, there are chances that tomorrow I will not be given trips.
Yeah. I think the issue of social protection is a bit wide.
Yeah.
And sometimes we think that the only way we can achieve social protection is to bring almost every worker within the definition of the employee, because that's the protected classification.
Yeah.
But sometimes it's okay to allow people to flourish differently.
Yeah.
Why? Because if you interact with the Uber drivers, they want to be able to have 5+ applications on their phone. I know I'll make money with safe border between 5 and 7.
Yeah.
But after 9, I want to move to Falaz.
Yes.
Then after that, I need to move to Bolt. Now, that is somebody who wants to control their time.
Yeah.
And that's a risk probably they will have to take to say,
Yeah.
if I choose this kind of gig economy, then I might sacrifice it for that NSSF. And I think some of the things cannot be corrected by legislation, but by awareness. To say, if you take this approach, these are the risks. Because we need that informal sector. And you know, like in Uganda, a lot of our economy is being supported by the informal sector.
Yeah.
You have casuals who say, today I'm at this manufacturing, lifting cement.
Yeah.
At 3, I'll move to breweries to lift crates.
Or become a bouncer.
Yeah, and at night. Because these 4 people offer different rates.
Exactly.
And I should be able to choose because I determine my time. Now, if you want to move that person to the employee perspective, it becomes difficult. That person can make 400 a month, but if you say you must choose where to belong, then because of the skill set, they might move their earnings to 150 by half. And that is something that, by the nature of the economy, it should be allowed. And maybe the previous conversation should be the one to make sense of maybe instead of fighting over NSSF, can we provide for the minimum payments, minimum wage?
Yes.
So that if I choose to move, I am still protected because there's a threshold below which company should not pay. That way, the government has protected its workers, but have not stifled the flexibility that is required. Because the understanding is that not everyone wants to be NSSF.
Yeah.
It's a good social protection, but it has a public service mentality to it. There are people who would say, I want to work for 5, 6 people. And these things are coming now.
Yeah.
You have the Generation Alpha that is being employed online. They play football, online football, and they get paid. They play games online, and they're the next generation of millionaires. They don't care about your NSSF in pensions.
I hear you.
Why? Because NSSF is another aspect of pension because of the job security perspective
syndrome
of the millennials and the baby boomers. But right now, things are different. And we have to look at social protection differently. We have to look at how we safeguard health and safety at workplace differently. Why? Giving somebody a loan to purchase a car was considered a serious employee benefit. Or giving somebody a house. But the Gen Zs don't even want to own a house. They don't want to own cars. Why? They're the biggest users of Ubers.
Yeah.
They want to use things, they don't want to own them.
Yeah.
So when you legislate with a millennial mindset, when you're in a generation of we use, we don't own, you will have a cross-generational clash.
I love that. We use, we don't own.
Yes. You know, our generation, you want to go to Chukutwe and be on 5 acres of land. A Gen Z wants to be close to town in an apartment in Nakasero, where he can access amenities within 2 miles radius.
Yeah.
They don't care about your acres of playing football. They are in high-raised buildings. So the employment law must have context of the generations we live in and what they actually need or want. Because social protection of the 1980s, 70s is not the social protection now.
Exactly.
They wanted permanent and pensionable retirement was a big thing. But here somebody says, I'm giving you 3 years in law practice afterwards. I'm going to play football for 2 years and then I'll move into tech.
Wow.
They're mobile. So when you say that you must give people long contracts of 10 years, whom are you legislating for? And the social protection has evolved over time. And that's why these conversations are important to say. And courts must be alive. Because you condemn a company that has 10 content creators who are not on the payroll, but they go sit somewhere in a cafe at Java House, do the content, post it. They have time for this company for 2 hours, and they get paid. They move on to another person and they are running their social medias. They are paid and they move on to another. And then you are boxing them into the traditional setup.
Yeah.
You kill creativity, you kill innovation, and you are affecting the economy in terms of the next generation of millionaires. Yeah.
I think you pass on a very, very key aspect, and that is the millennial mindset thinking for the Gen Z mindset.
Yeah.
You can pick it from this conversation where you see that my conversation is rotating around, oh, these people need to be protected. They need NSSF. Yeah? You know, these guys here, there need to be, health insurance. We need to know that NSSF should be able to knock on their door, or, the employer's door and say, wait a minute, why is Hagre, not having NSSF?
Yeah.
And that was the one key purpose of this conversation, that we tweak the system, we implore the system, so that even from the practice perspective, that we reduce the gap between legal practitioners in the employment sector vis-a-vis what is actually the reality.
Yeah.
That some of these agitations and professional advice we are actually rendering, we are rendering to the wrong people. Yeah? we are devising, and drafting policies for a number of these firms and companies. But in the long run, we're actually killing creativity.
Yeah. I just wanted to speak to that perspective.
Exactly.
I do a lot of policy drafting and reviews for organization, and one of the things I ask is about how old is your workforce? What's the average age here of your workforce? What's the culture here? And that is to speak to the nature of the policies so that you don't kill.
Exactly.
Now, one of the things that has been trending since COVID is remote work policy. Gen Zs now do not want to be judged on the process. Tell me what you want me to do and leave me alone. If I come to office at 10, it should be okay. Have I done what you told me to do?
Simple.
Judge me on the productivity, on the output, not the process. Now, the main approach is that, where is Tony? He has not reported. I want to see your work plan on how you deliver this project. So basically, you are almost suffocating this Gen Z who wants to play music, who wants to have his colored office, and probably at 4, knock off and go home. And next day, he will send you an email with a very creative project, probably more than what you expected. So if you have a policy that says you must report to work at 8 and leave at 5, Monday to Friday, that Gen Z will put in a resignation, or they will do what we call quiet quitting.
Yeah.
They are still with you, but they left the organization like 1 year ago.
They call it ghosting.
Yeah, ghosting. In HR, we call it quiet quitting. You think you have an employee, but that employee left a long time ago. Because you have policies that are not alive to the dynamics. And those are things that were not there 10 years ago. If you told somebody that I want flex hours, now they negotiate. You call a lawyer, said, can I come in on Monday, Tuesday, and Wednesday?
Yeah.
I will not be available on Thursday and Friday. Just tell me what you need me to cover in a week, and that is enough. That was never heard of 10 years ago.
Exactly.
Yeah. But now we must adjust the policies, we must interpret the laws, our discipline to fit within what we need, or what this generation can accommodate to ensure, one, productivity is still tick, the economy is growing, the basics of protecting the workers, employees, is still there, but not being bogged down by the traditional approach.
Wow. And to the lawyer out there listening, I think Patson, what's trying to say is we need to change the approach. We are not reinventing the wheel, but then I think the pedaling should change. Because we were not long ago dealing with a generation where we expected in Office 8 to, to 5. But the current generation and the employers we are advising, one, they are Gen Zs, but even the people they're employing are Gen Zs.
Absolutely.
So the question is, are you going to advise a firm based on old practice, and you are driving for them policies and human resource manuals and creating time that 8 to 5?
It is.
I think for me that's a learning peak, because normally we set up these conversations so that lawyers, employers, policymakers are able to check the trends in this digital transformation journey. And we took it upon ourselves. We can share this knowledge among ourselves. Yeah, because the system has all of us in there. This conversation today, if you had it with the Professor Barrier, 10 years ago, he'll say, what are you talking about? But these are realities of life. And I want to thank you really for sharing some of the things from a very practical perspective, because we seem to be giving the wrong script. And we seem to be sitting in these disciplinary settings because we are advising companies, we are company secretaries. So we are in these disciplinary hearings and we don't seem to understand each other. You're having this 25, 26-year-old employee saying, what do you want me to do? You give me work, I did it. And then you're having this MD who says, do you know you have not stepped in this office? Monday you came in at 10, you disappeared at 11. And then Tuesday. So there is a mismatch. And I think for me, this conversation needs to start. And I'm glad, there is no better person to have this conversation flowing than you, who has been at the forefront of employment revolution in our sector. I think it is very, very, very key. For the listeners, we are still having Patson Arinaitwe, and we are discussing briefs, bots, and gigs, navigating employment law in the digital age. And we are having what's the reality and what is the basic standard. We are finding a middle point between the standard and the reality. The law is based on the 1996 model brought in 2006, but then things have changed. The COVID changed so many things. So how do we balance the two as we advise and also as employees? So I think that is really very key. I would want us to, if you were made the Minister for Labor and Gender, with your expertise and the illustrious career in employment, what are those amendments you would recommend government to make in the Employment Act of 2006?
Well, Tony, that's a hard question, since usually I'm not a politician and try to keep away from politics. But one is contextualize employment law. One, you cannot have one size fit all. That is one. Two is to understand that there has to be changes that will happen over time. A classic example now is, since 2006, we've seen the growth of our oil and gas sector. Our law says you must work 8 hours a day, 48 hours a week. That's a maximum. Then overtime, 56. But the nature of the oil and gas industry requires that somebody will be in the field for a month. So you are calculating hours a day and a week and you stop there.
Yeah.
But you have an industry because of health and safety. Somebody will probably be at work for 1 full month because they stay in camps. But this person will be given 1 month off. So if that person is fired at the end of the year, he will say, I was overworked. I used to work 24 hours a day. And probably if you don't have a progressive judge, he would agree with them and they would ignore that this person, after working a month,
he rested for a month.
For a month. But our law has no context. So that is to create a framework. And some of these are based on regulation. At the moment, we say somebody can only be off work, or the employer can only suspend work for 15 days. Beyond that, technically the employer should release the employee. But we know what happened in COVID. We're in lockdown for virtually 2 years. If it wasn't for people saying, or the organization saying, we will not implement the law, or if they were to implement the law strictly, after 15 days, they should have laid off
everybody.
Because you have a duty to provide work. You are not providing work. So, and there's no context. We've not learned, for instance, the COVID situation, to make adjustments to our law to understand that force majeure, the suspension of work. We use, for instance, the word redundancy loosely, because redundancy means you are suspending work for a particular period of time, at least the way it is used in UK.
Yeah.
I still have my employment, you've suspended work and probably payment. But when work resumes, you can call me back. So my tenure will be preserved, but you are not under obligation to pay me or to provide for work. But for us here, we call redundancy when you are collectively terminating people.
Wow.
That's what we call redundancy, which is technically not the case. So there are certain situations that have shaped employment that we, as a ministry, we should learn from and actually make adjustments to the law. How do you provide the economy flexibility, not exploit workers or employees, but provide opportunities for the economy to thrive? Because ultimately, the owner of capital is likely to dictate. If circumstances don't favor, chances are that you will lay off people. When the law doesn't favor you, you will find creative ways on how to save the organization. And yet, if the ministry got to understand where we are, how do I deal with technology now? It's now part and parcel of our lives.
Yeah.
How do we ensure that this gig economy, the platforms, the remote work are integrated in our workspaces?
True.
When we talk about health and safety, we have moved away from the health and safety of where safety means free from your hand being chopped by a machine, to toxic work environments, to mental health as part and integral part of health and safety. But the way of our occupational health and safety is structured now, we are still in brick and mortar, accidents at work.
Exactly.
But now, the damage or the danger we are dealing with can't be touched. It's not a machine.
Yes, they're psychological, they're emotional.
Yes. You have emotional, psychological, mental health issues that the law is not addressing. And probably you need a progressive judge to say, to give the law wide and purposive interpretation to say health and safety includes the boss who decides to bully at work and causes mental health. Do we need that? Or probably that's what the ministry can't progressively adjust. So there's a lot. We have local content. It's a general concept, but also it's an employment concept. How do you protect the local workforce? Yes, we live in a global village, that's fine. But I think there's some bare minimum local content requirements to allow our people to work, especially where we have competitive skill sets. Why should somebody walk in? Currently I can get an organization and hire all foreigners. And that thing stops me from doing that in the current regime. But in other jurisdictions, you won't do that. You must demonstrate that you can't find an alternative from the locals. So the local content is probably only restricted to oil and gas sector in a few, but doesn't cut across. We had a local content law that has not been assented to. It has been kept. If I was minister, it's a conversation I would revive. Allow flexibility, allow measure of productivity beyond the brick and mortar, beyond defining a workplace by the walls, because now cloud is a workplace. People are now in workplaces outside. Java, you find somebody at Java House and they're working. Workplace is a computer if I'm signed in the system. It's no longer a desk. But our law is still presumes that a workplace, you must have an office somewhere. Yes, we have those circumstances, but also not forget that that might sound elitist. But also, how do you deal with casuals? How do you deal with the informal sector to structure them in such a way that they're also not exploited? If you're talking about don't allow somebody to be a casual for more than 4 months, what are the safeguards? What are the presumptions under the law to ensure that there's no exploitation? Because you are dealing also with the same skilled and unskilled labor. Actually, those need even more protection than the elite. But our focus is more with the elite than the masses. The maids at home. You know, some of my trainings, I ask people, you're asking for these protections at work.
Yeah.
But when you want to fire your house help, you pack their things at night and you put them in the bus in the morning. They don't even know what they did. But you come back at work. Yes. But you come back at work and you say, I was not given a right to a fair here and you did not write to me about irrigation. After you fired your maid at the morning without telling her what she did, can it cut across? Because by definition now, home is actually a workplace. That house help deserves rest. You cannot allow the house help to work from 7, some of them wake up at 4 a.m.
Yeah.
To midnight, Monday to Sunday. And you come to work and you are the one agitating for minimum working hours. When at home, you are not preaching, you are not practicing what you preach. So the understanding is that...
you are preaching water and drinking wine.
We're drinking wine, yes. So some of the protections is also for those vulnerable groups, and they need to be brought into the conversation. Yeah.
Well, thank you very much. I think just on, Patson, our time is well spent. We are 12 minutes beyond our normal time. And I will just speak one question which came from James from Fitzpa. He says, ask Patson, how does a startup company get it right from the time go? And then there was somebody called Susan, still from Fitzpa, who says, what would a Ugandan model structure be? I need to pick it right here. I think I saved it here. He says, what would be a Ugandan model for regulating a gig worker realistically look like? When you give us a context of those questions, then we should be able to wind this up today. The first one was, how does a startup in our setting get it right from the time go with respect to employment? And then the other one comes to... no, we're on YouTube.
Yeah. So I think to get things right is not to wait for the things to go wrong.
Yeah.
A startup needs to see far and bring things together. For instance, having basic compliant documents.
Okay.
Don't wait to have employees to have an HR manual. A manual or policy sets the culture of the organization. So knowing that the cost of non-compliance now is so high, it can actually take a startup out of the business. If I'm doing calculations of the risks, and I would expect every startup to have a risk matrix of what can go wrong and how do I mitigate.
Exactly.
The number one flag is the employment risk. And what do I do? One is, because it's a moving target, that cost of having a labor lawyer advise you from the start. How do you hire? How do I contract? to avoid misclassification. Maybe now the nature of the work at the very beginning requires that I use independent contractors, I pay them, they move on before I take on full time. So can I structure my workforce or human capital in such a way that I'm not exposed? Let me have consultants to build systems in place, and maybe 1 or 2 or 3 employees, but with contracts very specific and compliant. NSSF pay as you earn. And there can be ways on how to be creative in such a way you don't offend the law, but you are able to maximize employee benefits within the context of the business. So get the classification right. Get a taxman to assist you in the costing of the human capital costs. Otherwise, you may incur pay as you earn when you thought it was only 6% withholding. How are you managing your startup costs from the human capital perspective? Do you have proper documentation? And the way employment evolves, I'm not so sure, for instance, whether a general lawyer can advise the same way general lawyer shouldn't advise on tax matters. I'm not a tax lawyer, but I think there are certain areas of the law that require specialization that you need to think out of the box to advise, because the law in itself is not enough. It's not enough in such a way that you need creativity. Somebody to think out of the box using the law as a tool to help with the setup. Because the moment you get it wrong, then you realize that for the last 2 years, you are paying pay as you earn when you should have paid withholding tax on a consultant. Or vice versa. You should have paid NSSF, you are not paying. Then you have an assessment from NSSF with penalties involved, and then you have to close shop. Because you never got it right. Spend money. I think getting the right advice and structure should be among the setup costs. Don't say, I'll only need a lawyer once I'm sued. Lawyers are not magicians. If the facts are wrong, they are wrong. And probably you will only settle and spend money. But legal advisory is cheaper than waiting to get in trouble and then you want Tony to rescue you in the industrial court when the facts don't support you. So my advice is really take advice, proper documentation, and cost your employee benefits. Now the challenges with employee retention is very important. If you're a tech company, do you have non-compete clauses? You have confidentiality clauses that are critical within the ecosystem. You cannot pick an employment contract in an NGO world and you go and take it to Java House. Or you take it to a information sensitive sector. So you need to tweak your contract to protect your trade secrets, to protect what you need to protect for that business. If you are tech, maybe there's a lot you need to protect. So that employment contract might have clauses that ordinarily would not be in a clause when somebody's working in manufacturing.
Thank you very much, Patson. I think for James or Fitzpa, the take home is that you need to start it right from day one. Have the right policy documents, have the right compliance documents, and seek opinion of an expert. If you need to see how a tax person is going to structure for your tax, you need a lawyer to, draft for you the contracts that are fitting. Not generic. So we can't go beyond this. Ladies and gentlemen, thank you for tuning in. We had a bit of glitches today with our X handle, but our YouTube was very clear, and our technical team is going to do whatever within their powers to have this recording uploaded on our X space, so you won't miss out. I want to thank Patson, despite your busy schedule, for coming to share with the lawyers. Our listenership normally is 1,000, 2,000, and the biggest population actually young lawyers. So conversations like these ones are very impactful, and we thank you for being part of the digital transformation journey in our legal sector, and for sparing time. I know you're a very, very busy person. We want to thank you, and we can't go beyond this.
Yeah.
We just want to invite you to give one parting shot. What advice, which is a common question I normally ask one of our guests because of the clients we have. What is that advice you'd give a young lawyer who has just come out of law school, who is interested and has been inspired by your practice in labor and employment sector? What is that advice you give that young man or young woman to make it right, to be the next person? Thank you.
Yeah, thank you, Tony, and of course I appreciate the opportunity to share this, and thank you for organizing this. It takes resources from you, time, and I'm sure this is not a setup where you are paid for this, but I really appreciate what you're doing for us as a society. For the young lawyer out there, for me, two things. One, there's no substitute to hard work, to putting in time. I'm not aware of any successful lawyer or any entrepreneur who would not tell you that I had to put in time.
Yeah.
That is a non-negotiable. You've got to put in time. And putting in time does not mean that you must first get 20 years or 30 years. But if you want to accelerate your growth, then you must put in time. But also that insatiable desire to learn, the quest for knowledge in a particular space is a game changer. And not just desire for knowledge in law itself, but in the space you want to play in.
Yeah.
Now, many people, for instance, I interact with so much nowadays are business owners and human resource people.
Yeah.
And every time I interact with them, it challenges my perspective on employment law. Oh, this is what is trending.
Yeah.
Is my advice still relevant to this? So that network, not only that for your likes, but also for the industry, for the professional you serve, and getting to understand how the business operates, how the environment. Because our advice will always be contextual.
Exactly.
So if you lose the context, then your advice will be pre-colonial days when we've moved in now Generation Alpha, maybe in the next 5 years. We're not going to be discussing Gen Z. The Generation Alpha will be in the workspace.
Exactly.
How do they operate? So the desire to learn, the desire to understand and put things in context sets you apart. Once you pick a line of where you want to practice in, put in time, learn, specialize, get mentors, but above all, prepare and put in time.
Wow. I think we can't go beyond this. Just like the property consultant says, location, 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 and location. What person is saying to a young lawyer who wants to excel in employment law practice and any other area, his factor is simple. Time, put in time, put in time, put in time. Put in time squared. Thank you very much for sparing time, Patson. And it was a pleasure of hosting you on Lego Tech Dialogues. Please don't get tired of us. We would want to continue tapping more, and we want to wish you a happy Easter on behalf of the Lego fraternity and the Human Resource fraternity. I'm sure they were listening in. I've seen many of them send me messages here. And also our colleagues from FitSpa who are very eager for this conversation today. Thank you. Thank you very much. And we look forward to hosting you again. Thank you.
Thank you. Pleasure.
Thank you.